I'm audible? Okay. Good evening, everyone. I'm CA Rekha Panjwani, moderator of this webinar. We are delighted to welcome you all in the webinar being organized by CCLEA and NPO Committee of ICI. It is my pleasure to be a moderator in webinar on agreement to sell under RERA. Nowadays, we all are investing in a real estate, so it's a very interesting topic, I think. Okay. It's organized by Committee on Commercial Law, Economic Advisory, and NPO Cooperative of ICI. In a short while, we will start this webinar. This committee is focused to encourage chartered accountant to shape strategy and policy that unlock economic, financial, and social value while combining analytical foresight with the commercial acumen. One of the core area of this committee is to serve the multifunctional task analysis, knowledge, input to regulator on policy formulation, to develop and publish technical guidance, background material, etc., and to create the awareness for professional opportunities for chartered accountant in commercial law, economic advisory, and NPO cooperative. Our eminent speaker will talk about agreement to sell under RERA in this webinar, and we hope that the same shall be useful to all of the members. Now, I would like to say about the prominent speaker, CA Yogesh Kumar Goyal, sir. He is working since 2001 as a CA. An area of practice is income tax, GST, RERA Act 2016, Tenancy Act 2021, Apartment Act 2010, and auditing. Having experience of regulation of a project under RERA, quarterly compliances, and litigations on behalf of builders and buyers. He also gives consultancy to various builders on RERA Act 2016, Apartment Act 2010, and Tenancy Act 2021, delivering lectures on various topics of RERA Act 2016 and the Uttar Pradesh Regulation of Urban Premises Tenancy Act 2021, Apartment Act 2010 in various educational seminars of ICI and Advocate Bar. Now, I would like to all the members to welcome our prominent speakers, Yogesh Kumar Goyal, sir. Sir, over to you.
Thank you, ma'am. Thank you, CCNPO committee, to giving me the opportunity to share my views on this topic, agreement to sale under RERA Act 2016. I am starting my presentation. Today's topic is very interesting topic because each and every person are either investing in the real estate or needs real estate for his own living, profession, commercial use, etc., etc. And it is not possible in the tier 1 city, tier 2 city to own a property with along with land. So each and everyone has to go to a promoter or builder to purchase a property. But this business has so many malpractices. So being a professional, being a investor, we should be aware about our own rights and duties, about the agreement which we will execute with the promoters. So now I am starting my presentation. When the RERA Act came in the year 2017, RERA was full-fledged effective from 1st May 2017, and the main object or the preamble of the act says the object of to establish the RERA authority is for regulation and promotion of the real estate sector, and to ensure sale of plot, apartment, or building, as the case may be, or sale of real estate project in an efficient and transparent manner. And third is to protect the interest of the consumers in the real estate sector. When we came to these three points, because the regulation and promotion, efficiency and transparency, and third is to protect the interest of the consumers. Earlier, there was no standard format for agreement to sale. Each and every builders, promoter, and
Recording
always
stopped.
this type of agreement were one-sided, and
Recording in
and they
progress.
do not have the home buyer or the or the purchaser of the property does not have much rights as required, as to be required by a home buyer. So, having regard to the object of RERA Act, efficiency and transparency, regulation and promotion, and to protect the interest of the consumers, state governments of each and every states has notified their agreement to sale, and agreement to every booking or every purchase of property should be executed through this agreement to sale notified by the state governments. More or less, as all the state governments has notified their agreement to sale, I am taking the agreement to sale of UP, Uttar Pradesh government, and I would like to say that around 80 to 90% of the agreement to sale are same. Only some points are differ by each and state by state. So if we understand this agreement to sale, and we can go through our own state agreement to sale, so we can understand this topic easily. RERA Act 2016 has defined under section 2C what is agreement to sale, and they have nothing to say. They simply said agreement to sale means the agreement entered into between the promoter and the allotee. Means whatever the agreement is being entered between the promoters and allotee, that is agreement to sale. Now come to section 13 of the RERA Act. RERA Act prohibits a promoter to take more than 10% of the cost of the flat or apartment or unit before executing agreement to sale. So section 13 itself says no deposit or advance to be taken by the promoter without first entering into the agreement for sale. So number one, not more than 10% amount can be collected from the allottees before executing any agreement to sale. And second is this agreement must be registered with as per the local laws. And local laws means Registration Act. As per the Registration Act, this agreement should be registered. And agreement must be executed in the prescribed format. After the enactment of RERA Act, the format of agreement to sale has been prescribed by the state governments, and it becomes rules under the RERA Act. So the format must be followed, must be agreement must be executed in the prescribed format only. And under the section 13, it says that following things must contain in the agreement. Number one, particulars of development of the project. What type of development is going to be done by the promoters? Number two, particulars of construction of building and apartment. Number third, specification of the project and unit. What are the specification? What are the features? They have to mention in the agreement. What are the internal development works and external development works in the project? Dates on which the allotee has to pay the amount to the promoter, and the landmark. Landmark means in case of multi-story building, you can say that construction of first floor, ground floor, third floor, 20 floor, 18 floor, on which the allotee has to pay the installments. Date of handing over the possession, on which date the possession of the apartment, plot, building will be handed over by the promoter to the allotee. And what are the rate of interest? Rate of interest payable by the promoter to the allotee and vice versa, and allotee to the promoter in case of default, and other particulars as may be prescribed. That this is the section 13. It makes mandatory for a promoter to take more than 10% amount only when the agreement to sale has been executed, and it must be registered as per the local laws. However, in many states, it has not registration procedure has not been followed, but it is mandatory as per the section 13 of the RERA Act. And different states has prescribed format issued. I have taken the North Indian states. Uttar Pradesh has notified agreement to sale. A separate rule has been notified with effective from 17/10/2018. Haryana 28/7/2017. Rajasthan 1/5/2017. Delhi 1/5/2017. And Punjab 17 6, 2017. These are agreement to sale are rules. So each and every promoter has to follow the rules. Features of the agreement to sale UP. यूपी के मतलब each and every state has this para in their rules. Any application letter, allotment letter, or any other document signed by the allottee in respect of apartment, plot, or building prior to execution and registration of the agreement for sale, lease for such apartment, plot, or building, as the case may be, shall not constitute to limit the right of and interest of the allottee under the agreement for sale, lease of under the act, or the rules or the regulation made thereunder. Means if you are executing, if we, even you have executed the agreement to sale before the enactment of the RERA Act. But as these are rules, so your right will be protected through this agreement for sale, and you can enforce your right through this agreement for sale. Even you have signed application letter, allotment letter, or any other document or any other agreement. So much effective these rules are, as your right has been protected as a allottee through these rules. Agreement to be executed between the two parties. Two parties means one is promoter or maybe promoters, and other is allottee or maybe allottees. So what are the contents of the agreement to sale under the UP agreement to sale oblique lease rules 2018? As I have already told that I have taken the base of UP RERA rules, but I assure you that 80 to 90% are the provisions are same in all over the states. Number one, date of execution of agreement. We have to mention on agreement to sale on which date this agreement is being executed between the promoter and the allottees. Why this date of execution is very important? Because as per the Registration Act 1908, every agreement to be registered within 4 months from the date of its execution. So date of execution of agreement is very important because you can register that agreement within 4 months of its execution. Number two, declaration of details of promoters and allottees that the agreement is between the following parties. Promoters, if promoter is a company, then following details has to be mentioned. And if the allottee is a company, he has also to mention following details. Why this is very important? This is important because if there is a dispute between the parties, if there is not no the correct parties, agreement is not between the correct parties, you cannot execute this agreement. You cannot enforce this agreement through RERA authorities. So very carefully you have to mention who are the promoters and who are the allottees. So full name of the company, you have to mention full name of the company in both the cases, SIN number, incorporation under the whether the company is incorporated under 1956 or 2013, address of the registered office, address of the corporate office, PAN of the company, name of the authorized signatory, Aadhaar number of the authorized signatory, board resolution which has authorized for signing the document on behalf of company, either for promoter or allottees. So these details has to be mentioned in the agreement by both the parties. If both are companies, or either promoter is a company, that he has to mention these details. Now, if the promoter is a partnership firm, promoter or allottee is a partnership firm or LLP. So if we, in that case, following details has to be mentioned in the agreement that these parties are executing the agreement. Name of the firm, registration number of the firm with registrar of firms. If the firm is an LLP, then LLP number or address of the principal place of business, PAN of the firm, name of the authorized partner, Aadhaar number of the authorized partner, and resolution, partner's resolution that this partner is eligible to sign or execute the document of this agreement to sale. If the promoter or allottee is an individual, Then following detail has to be mentioned: name of the individual, father name of the individual, address of the individual, PAN of the individual, Aadhaar number of the individual. One very interesting thing is there: HUF cannot be promoter under the Real Estate Regulation Act. RERA authorities are not allowing any HUF to be registered as promoter under the RERA Act. But an allotee can be an HUF can be an allotee of the unit. So, as a allotee, following details has to be mentioned in case of unit is purchased or plot is purchased by the HUF. Name of the Karta, Aadhaar number of the Karta, father name of the Karta, age of the Karta, address of the Karta, and PAN of the HUF. Next thing, the promoter has to mention details about the land on which project is going to be constructed. If the land is wholly owned by the promoter, then he has to mention what is the khasra number, survey number, or identification number of the project land, as per the tradition of that state. Because in UP we mentioned khasra number or survey number for the uh, verification of land or identification of land, and the area of land in square meters, address of land and district in which the land is situated, and sale deed or lease deed of the land, details like registration and source of ownership, where the ownership has been gained by the promoter who was the earlier owner, details of the land along with sub-registrar where the registry of that land has been executed. So if a person want to get the documents verified, then he can go to the sub-registrar office and get the information from respective sub-registrar of that land. If the land is under collaboration agreement, is land is obtained under collaboration agreement, development agreement, or joint development agreement, it means there are more than one promoter in the project. So details of first promoter having land is to be mentioned as above given in para 1, and also the developer promoter information has to be given, and date of registration information regarding collaboration agreement, registered collaboration agreement, development agreement, or a joint development agreement as such given regarding the point D of para 3.1 point D. All the details like registration of that collaboration agreement. It is clearly to be mentioned that what type of a land is there, whether it is a commercial land or residential or any other use or mixed use or industrial use. It must be clearly mentioned in the agreement. If the project is multi-storied, then how many stories, how many floors the promoter is going to be constructed has to be mentioned clearly in the agreement. In case of plotted development, number of plots which are going to be sold by the promoter has to be mentioned clearly. And name of the project. Name of the project should be as per the project registered with RERA authority. Nowadays, RERA authorities are very strict. They are saying that the name of the project should be same as mentioned with the development authorities or competent authorities or DTCP. Next is declaration about the approval of the project. This is the responsibility of the promoter to declare with the allottees that what type of license he has about the project. Name of the competent authority or development authority or DTCP granted commencement certificate who has approved their project for construction. That are competent authority, development authority, DTCP. I am in Ghaziabad. Here the competent authority is Ghaziabad Development Authority. In Delhi, it is DDA, Delhi Development Authority. And in Haryana, their offices are called DTCP. So these are the authorities which approved the maps of the project. So And after approval of map, if all the conditions has been satisfied by the promoter, they issue commencement certificate that you can now start construction on your project. Date of commencement certificate, on which date the promoter can commence the construction on the site. Next, registration number of the project granted by the competent authority, development authority, DTCP, granted, who has granted commencement certificate. So registration number, they are also give a sanction plan, they approve sanction plan, they mention on the sanction plan what is the registration number of the project. So that registration number has to be mentioned in the agreement to sale. Number 4 is layout plan, sanction plan, specification, all things, airport authority clearances, environment clearances, other necessary clearances has been taken. What type of clearances has been taken by the promoter? All has to be mentioned in the agreement. This is a disclosure given to the allotee by the promoter. Commitment by the promoter, changes to be done only as per section 14 of the RERA Act 2016. The person who was in practicing in RERA knows section 14, about the section 14, that a promoter cannot change the map or sanction plan of the project on its own. He has to take permission from at least 2/3 allottees, and also to take permission from the RERA authority. So here the promoter gave declaration that I will change the map of the project only as per the conditions given in section 14 of the RERA Act. And last, project registration number obtained from RERA authority and date of registration. All these things has to be mentioned or declared by the promoter in the agreement. Now the information is to be given about the unit, plot, apartment, whatever maybe call, maybe a office, uh, or it may be uh, plot, apartment, flat. So these the information about these booking, number one, key on which date the booking has been done by the allotee, and what was the application number of booking, date of application by the allotee, on which date the application has been received by the promoter, unit number, floor number, tower number, if unit is in a multi-storied project, and if if it is a plotted development, then plot number, area of plot is to be mentioned by the promoter in the agreement to sale. Further, in case of a multi-story building or a villa, or it may be office space, or maybe flat, the promoter has to clearly mention what is the carpet area. Carpet area has already been defined under the RERA Act. And parking area with location. Here, I want to say one thing. At present, the promoter is not mentioning. They are mentioning that one parking is free, or two parking is free, or the parking charges are so much. But they are not giving location of and at which location parking has been allotted. So it is very important that if you are giving the location of your flat, parking area location has to also to be mentioned in the agreement, and also the common area. So you cannot simply say that super area is something, and you have to bifurcate that area, super area, into three parts: carpet area, parking area, and common area. And all these details should be mentioned in square meters. Earlier, the promoters sells the unit in square feet, square yard, but it is necessary that all this information should be given in square meters also. And if the open in case of open parking is sold, or sorry, if the in case of open parking is allotted, then slot number should be given, should be mentioned by the promoter, and and it will be free of cost to be rectified by the RWA. Open parking cannot be sold because open parking is always in the open area of the project, and open area is the part of common area of the project. So that area cannot be sold by the promoter, and it must be free of cost. Confirmation by both the parties. Now both the parties are giving confirmation about that they have read and understood the terms and conditions. They cannot simply say that I have not gone through the paras of the agreement. Now both the parties are confirming that they have read and understood the terms and conditions. Agreement must be signed by both the parties with full knowledge of, and they are also giving undertaking that they have full knowledge of law, rules and regulation applicable on the project. Next is both the parties relying on the representation of both of the parties, that and then entering into the agreement. The significance of this para is because the promoter is giving declaration about land, project land, about the unit, about the cost, about the area, and an allotee is relying on this statement, and also the promoter is relying on the allotee's statement that he has the sufficient resources to pay the cost of the flat on the due date of landmark. So both the parties are relying on the representation of each other. And one thing more, promoter agrees to sell. Promoter is saying that I am agree to sell, and allotee is saying I am willing to purchase as per the terms condition of the agreement. So both the parties are giving their confirmation about these points. Now the next point is disclosure of the price of the unit oblique plot. How the price should be mentioned in the agreement. Price of the unit, price of the carpet area, price of the plot should be mentioned in square meters. And it also mentioned cost of garage or covered area, cost of common areas, taxes applicable on the unit, maintenance charges, external development charges, internal development charges. These two charges has been uh, added by me, external development charges and internal development charges, because the builder charge these amounts. What are the significance of these figures? Because the price once fixed, can the promoter cannot demand any extra amount on this amount. So whatever he want to charge from the allotee, he should be clearly mentioned in this agreement. All this amount are the part of the cost of the unit, because as per the agreement, this price include taxes, GST and other taxes, all the types of taxes, up to the date of handing over of the possession of plot, apartment to the allotee, and the project to the association of allotee, competent authority after obtaining completion certificate. Means when the promoter would got completion certificate, till till that date, all the amount which are required to be collected by the promoter is including in the price. So he cannot demand any other amount except the amount mentioned in the agreement. Further, if the taxes are increased, because it is written in the agreement that the applicable law, all the applicable law for the time, this the amount has been decided as per the applicable law for the time being in force. And if there is any change in the law, then the provisions of new law will be applicable. So if the rate of taxes has been changed after booking, then increase or decrease in the amount will be collected. If the taxes amount is been increased, then such amount can be collected by the promoter. And if the amount of taxes is decreased, that amount can be reduced based on the changes or oblique modification. But there is a conditions. If rate of tax is changed after due date of completion of project as per the registration or extension thereof, then such increased taxes cannot be collected from the allottees. Then this amount cannot be demanded from the allottees because here the promoter is on default because of non-completion of the project in time. So the excess amount cannot be demanded from the promoter. Further, the total price include price of land, construction cost of the apartment and common area, internal development charges, external development charges, taxes, cost of providing electrical wiring, electrical connectivity to the apartment, lift, water line, plumbing, finishing and painting, marbles, tiles, doors, window, fire detection and firefighting equipment in common area, maintenance charges of period, cost of providing other facilities, amenities, and specification mentioned in the annexure of the agreement and in the project. I have already earlier said that this fixed price include all each and everything. So the promoter cannot demand above this amount. So even if you are allotee, you can say that this price including such and such things. Now you cannot demand any extra amount from me on this amount. Number two, one more declaration is required to be given by the promoter that the price shall be escalation free. Earlier, when we see the agreements between the allottees and promoter, they say that the price has been decided as per the present rate, and if any increase in the prices will be decided as per the RBI inflation rates, and escalation will be charged accordingly. But when the RERA Act was enacted, the object of RERA Act was to bring transparency in the price also. So the RERA has said the price shall be escalation free. So no escalation can be taken or charged from the allottees. If development fees increases by development authority during the project registration date and extended project registration date, that can only be collected from the allottees. If development authority or competent authority increase the development fees, means IDC or EDC. If increased, then this amount can be collected during the project registration. Only after that date, this amount cannot be collected from the allottees. And what are the conditions of issuance of demand letters and its payment? When can a demand letter be issued? When how the payment of the demand will be paid by the allottees? So these are the conditions mentioned in should be also be mentioned in agreement to sale. Number one, promoter shall issue demand letter time to time as per the completion of the landmark mentioned in the agreement to sale in writing, and amount and taxes will be shown separately. I have seen many agreements between the promoter and allottee, which was older one, where it has been written that promoter shall not issue any demand letter, and the date mentioned in the agreement will be the due date of payment. And in case payment has not been made in time, then the promoter can collect interest from the allottees, and if the amount has been not been paid, the unit can be cancelled. But now, as per the agreement to sale rules, it is mandatory for the promoter to issue demand letter time to time as per the completion of landmark mentioned in the agreement, and the taxes amount should be shown separately. One more thing I would like to share with you, as we are mostly chartered accountants and know about the GST law, and there are e-invoicing in respect of suppliers having turnover more than 5 crore rupees. So I think in each and every case, there are turnovers more than 5 crore rupees. So the promoter or builder is required to issue e-invoice. But in most of the cases, demand letter are issued on plain papers, not on e-invoice. So they are doing such default in issuing demand letters because the demand letter, if the demand letter is issued, they are not paying, not depositing GST to the department. But if they issue e-invoice, then they have to deposit GST with the department timely. Next is time period in which this demand will be payable should also be mentioned in the demand letter. So a reasonable time should be given by the promoter to the allotee to arrange the fund, and so he can pay the amount to the promoter as mentioned in the demand letter. One more thing is details of bank account. As you know, as per section 42 LD of the RERA Act, a separate account amount can be collected by the promoter in a separate bank account. And so details of that bank account are also to be mentioned in the demand letter also, and also in the agreement, each and every document issued by the promoter. Here in UP, UP RERA authority has issued guidelines that bank account and means collection account where the amount will be collected and deposited in the account of the promoter. The amount collected from the allotee should be deposited in the collection account only. So it should be mentioned in the agreement also, and also in the demand letters of the promoter also. Next is early payment discount can be given by the promoter, but once the discount is given by the promoter, it cannot be taken back by the promoter. Next is the responsibility of the promoter is to construct the project according to the landmark fixed in the agreement, but according to the constructed milestone or landmark declared in the agreement. Allotee shall pay to the promoter as per the written demand letter in the prescribed time, as fixed in the milestone in the agreement to sale. So both are responsible. The promoter is responsible to construct the project timely and as per the landmark, and the allotee is responsible to pay according to that landmark. If allotee is residing outside India, then he has to follow Foreign Exchange Management Act 1999 and RBI Act 1934. The provisions of these two acts has to be followed by the allottees. And if there is any liability incurred on the promoter, then the allotee is responsible to make it good or compensate to the promoter. For these things, promoter is not liable, as these compliance has to be done by the allotee only. Further, if you are paying the amount to the promoter by single transaction, but there are different types of demand due against you, then promoter can adjust that amount in different heads without uh, without your permission. He has the right to adjust that amount in different heads of the demand. Next is any addition, alteration in the sanction plan, layout plan, which we have already discussed. Layout plan is specification, nature of fixing, fitting, amenities as per attachment, prospectus, etc. cannot be changed without previous permission of the allottees as per section 14. So two-third allottees permission is required to be taken by the promoter, and also the permission from RERA authority has to be taken by the promoter. But in case of minor changes are there, no permission is required either from allottees or from RERA authority. Now the final demand. Because when when the promoter issue attachment agreement to booking or execute agreement to sale, it mentioned carpet area of the unit, but the actual carpet area of the unit may be differ from the area mentioned in the agreement, etc. Then when he got completion certificate or occupancy certificate of the project, he has to disclose the correct carpet area with the allotee. And in case whatever, if the amount has been collected more, then the promoter is responsible to refund the amount along with interest to the allotee. And if the amount is if the area is increase in such a case, on next landmark he can collect the increased amount in increased area. But one thing is there in UP, UP RERA authority allow 3% of the variation in the carpet area. In Haryana, it allows 5% of variation in the carpet area. So you should check your state agreement to sale, what type of percentage they are allowing in variation allows in their agreement. So in my opinion, if the this area is increased by more than such percentage, further excess amount should not be paid by the allottees. What are the right of right of allottees, association of allottees as per the agreement? This has to be mentioned in the agreement to sale. What are their rights? The right of exclusive ownership of the unit. The allotted unit, when the allottee paid full amount, in such a case, he has get exclusive ownership of the unit. Further, he has the usable right of the common areas along with other allottees. So he can use only the common area. He can use the common areas. He is not the owner of the common areas. But as per the Apartment Act in UP, these common area is also transferable to allottees. But now, as per the section 17 of the RERA Act, the common area is only having usable right, and it cannot be transferred to the allottee. Now, next is common area should be handed over to AOA, means Association of Allottees, or the competent authority by the promoter after getting completion certificate from the competent authority. This has to be done by the promoter. Allottees have the right to visit the project site and unit. You can go to the project site and can see what type of working going on in the unit or at the project. Next is parking and garages. If you have booked one parking or garages, you cannot separate these parking or garages from your unit, plot, flat, commercial unit, offices, villas. You cannot separate that. If you want to sell this unit further, then parking will be sold along with this unit without any means you cannot keep separate parking along with unit from the unit. Sorry. Next is this declaration is to be given by the promoter that project is independent, self-contained project covering the land and not a part of any other project or zone, and shall not be combined with other project except for the use of infrastructure for benefit of the allottees. Means all these information is to be given by the promoter that the project is independent and this is not part of any other project, and whatever the common services are going to be used, they are used by the allottee only, and the other project person will not use uh, that common services, common facilities, yeah, amenities. So this declaration is very important. There are many disputes where the common services, common facilities are used by many project person, many allottees of different projects. So you can claim your right that this is the infrastructure of the common area will be used only by the allottee of that project only. This has already been covered. Project facilities and amenities shall be available for use and enjoyment of the project allottee only. And the responsibility of the promoter, what is the responsibility of the promoter in case of uh, possession is handed over to the allottee? The promoter has to declare. This is section 11(4)(g) of the RERA Act. that promoter shall pay all the outgoing still physical possession of the unit which has been collected from the allottees. Number one, land cost. Because here he may have purchased land from the competent authority or development authority or any other person. So land should be fully paid. Ground rent, any municipal tax, ground rent, or any other local taxes, he has to pay to the respective authorities. Charges for water and electricity, maintenance charges, mortgage loan, interest on mortgage loan, other encumbrances, liability payable to the competent authority, bank, financial institution of the project. Means when an allotee takes possession of the unit, it should be free from all such type of liabilities, which is the responsibility of the promoter. Next, if the promoter does not pay the amount mentioned in above, then he shall be remain liable for payment of such amount along with interest or any penal charges. He cannot be absolved from his liability for paying such and such amount even after handing over possession to the allotee. And next is booking amount paid by the promoter. Paid to the promoter shall be part of the consideration of the unit. In case of defective title of land, the promoter is of the project land of the promoter in the project land, then interest and compensation can be collected from the respondent. Such complaint shall not be time barred. Means if there is a defective title, suppose you came to know after 20 years of taking possession of the flat that the land on which this project is being constructed has a defective title of land, is owned by the defective title of land by the promoter. In such a case, you can file your case before RERA authority, and there is no time limit for filing such a case before RERA authority, and you can get interest and compensation from the promoter. In case of delaying handing over possession by the promoter, the allotee, if allotee wants the possession, then delay interest shall be paid by the promoter to the allotee on demand by the allotee. Then it means you have to demand the delay interest from the promoter, then he will be liable to pay in case of delay in project. Or in case of delay in handing over possession, if you do not want to stay in the project or you want to refund the amount, you can get a refund amount and delayed interest, and also you can get compensation from the promoters. There is a one difference between both the conditions. If you want possession, then in such a case, compensation is not allowed. But in case of a refund, you can get compensation also. Possession of the apartment oblique unit. Promoter shall hand over the possession of the unit along with ready and complete common areas with all specification, amenities and facilities of the project on a particular date. If the promoter is going to hand it over your possession, all the facilities, amenities, specification, as mentioned in the annexures, there are 5 annexures in uh, every agreement to sale, which I have taken in the last of this presentation. So these should be completed before handing over of possession to the allotee. Further, possession period may be extended due to force majeure. Force majeure condition. What are the force majeure conditions? War, flood, drought, fire, cyclone, earthquake, or any other calamity caused by nature affecting the regular development of the real estate project. As we know, COVID-19 was there 3 or 4 years back, and it affects all the projects. So, and the government has also declared that COVID-19 as a natural calamity. So, possession period may be extended in such a case, and assuming that a force majeure, and the period of possession shall be extended because of that reasons. Further, if the possession is impossible due to force majeure conditions, then promoter shall refund amount of 120 within 120 days from the termination of agreement. 30 days prior notice is required for such termination. If the project it is not possible for him to construct the project. Then 30 days prior notice is required to be given by the promoter to the LOT, and all the amount should be refunded within 1 to 20 days from the date of termination and without interest. Then in such a case, no interest will be given to the LOT. Further, normal maintenance charges can be collected by the promoter till the project is handed over to the AOA, Association of LOT. Section 11.4 contains one provision that the promoter till the handing over of the possession to the AOA, the promoter can charge only the normal maintenance charges. He cannot charge maintenance charges more than the market rate given applicable in at that area. Number two, next is possession of the unit shall be taken by the LOT within 2 months from the date of completion certificate or occupancy certificate. So 2 month in 2 month times, possession should be taken and conveyance deed should be executed within 3 months or as per the local law from the date of completion certificate or occupancy certificate. But I would like to mention one thing. Uh, this is section 17 and section 1910 and 1911 of the RERA Act. But the Apartment Act are opposite. Even the Registration Act is also opposite about this of these provisions. The Apartment Act says that without executing registered deed or transfer deed, you cannot give possession of the unit to the person. And also, Registration Act says or Transfer of Property Act says that possession can only be given after executing transfer deed or registry deed. So, but the RERA Act will prevail over this provision as per the section 89 of the RERA Act. Further, the documents which are required to be handed over once the project is completed, the right of the promoter will become very limited, and now the project will be handed over to the AOA, Association of Allottees. In such a case, the documents of project plan or common areas or electricity electricity map or water pipeline map or even fire map, all should be handed over to the Association of Allottees, because in future, if there is any emergency without map, that cannot be repaired or maintained by the Association of Allottees. Failure to take possession of the unit. If allottee pay full amount to the promoter but does not take possession of the unit, then the promoter has the right to demand holding charges as mentioned in the rules or agreement from the allottees. In UP, there are rates has been given in case of flats or constructed property. The rate has been given 2 rupees square feet per month, and in case of plotted development, the rate has been given rupees 1 per square feet for holding charges. Cancellation of unit by LOT without having any fault of the promoter. If you yourself want to cancel the unit, then in such a case, booking amount will be forfeited by the promoter, and 50% of the remaining amount shall be paid in next 45 days, and remaining amount shall be paid by promoter within 1 year or reallotment of the flat, whichever is earlier. So there are, in case of allotee himself want to withdraw, these are the conditions. You will in amount will be paid without interest. Now the what type of warranties or representation is being given by the promoter while executing this agreement? These warranties or guarantees or representations are very important. Number one, the promoter has absolute, clear, and marketable title in the project land, because means the land is dispute free. And as you know, as per the Contract Act, what type of right you have, you can only transfer that type of right to other person. So if you are if the promoter has the clear title, clear right, then the same can be transferred to allotee also. Next is the promoter has requisite a right to carry on development upon the said land. The right from collaboration agreement, development agreement, joint development agreement, or if he has himself the owner of the land, then he has got approval from the requisite development authority. The promoter has absolute, actual, and physical and legal possession of the project land. That he has the right to construct uh, the promoter has absolute, actual, and physical and legal possession of the project land. So this proves that he can construct the project on the subject land. The promoter has lawful right and requisite approval, actual and physical and legal possession of the project land. Means he has the possession of the land. He has also taken approvals from the respective development authority, competent authority, even through the collaboration agreement, joint development agreement. He has the right to construct the project. No encumbrances on project land. There is no loan has been taken on the project land, or if the loan has been taken, details of such loan should be given in the agreement. No litigation is pending against the project land, project, or unit. If there is a litigation pending before the any authorities or any court, that should be clearly disclosed by the promoter to the allotee. I would like to mention one thing. In many cases, the unit of the unit of the allotee has been cancelled by the promoter and sold to the other allotee, other person. And if the unit of the allotee is cancelled, the first allotee go into the court, but this disclosure has not been given by the promoter to the second allotee. That one case is earlier allotee has filed one case in such a case, and in such a case, your unit may be cancelled. So please read carefully the agreement, that such an information is not there in the agreement. If such information is not there in the agreement, the promoter has all type of approval licenses like sanction plan, development plan, airport authority permissions, permits, environment clearance, water clearance, firefighting clearance, all type of clearance which are required for construction of a valid construction. It has all the informations. Promoter has been and shall all the time remain to be in compliance with all applicable laws in relation to project, shed land, building, unit, and common areas. This is very important because in many cases we see that the promoter got registration from the RERA authority and it lapses, but he does not extend the registration. But here, what he is saying that uh, that he will comply all the provisions of all the acts. Even the sanction map is normally issued for a period of 5 years, and that sanction map got expire, and promoter does not extend that map. So this is very important that he will follow all the applicable laws. So you can force him to comply all these type of laws. So you can protect your right as a LOT in the said project. The promoter has the right to enter into the agreement. Suppose in case of collaboration agreement, the right of to enter in the agreement is not been given, but the promoter enters into the agreement. This will hamper your right because he has no authority to enter into the agreement. So please check that this line is should be there in your agreement, and also that line should be given in the collaboration agreement also, that this person is authorized to enter into the agreement with allottees. The promoter has not entered into any agreement which affects the right of the allottees. Next is the promoter shall at the time of conveyance deed hand over lawful, vacant, and peaceful physical possession of the unit to allottee and common area to the association of allottee. The scheduled property does not belongs to HUF or minor. As I earlier said that the promoter can sell a property to HUF, but HUF cannot be a promoter because there are fourth generation and HUF is continue for fourth generation. So there may be a dispute of ownership of the HUF property. So in such a case, RERA authorities are not allowing HUF as a promoter. Further, no notice of acquisition or reacquisition of said land has been issued by any authority. The land on which the project is being constructed is not acquired by government or any authority. This has to also to be declared by the promoter to through this agreement. Reason reason when promoter became defaulter and its consequences. When a promoter can be said that he is a defaulter, if the possession of the unit is not been given in time except due to force majeure, or business has been discontinued due to suspension or revocation of registration. I am taking a 2-minute break, then I will start again. The reason when promoter became defaulter and its consequences. Only two conditions are there when we can set the promoter has a promoter is a defaulter. If the possession of the unit not been given in time except due to force majeure, or business has been discontinued due to suspension or revocation of registration. Only in these two conditions we can set that the promoter is a defaulter. And what will happen? What are your right as a LOT? If the possession is not been given, then you can stop the payment of the promoter uh, and till the next milestone, till the milestone has been achieved by the promoter. Or If you want to refund, you can terminate the agreement and promoter shall be liable to refund the entire amount along with interest on the prescribed rate within 45 days of termination. In UP, the rate of interest has been prescribed as MCLR plus 1%. In Haryana, it is also been prescribed as MCLR plus 2%. So different states has prescribed different rates. You have to check your state rates. What are the prescribed rate of interest as per the RERA? And if the allotee wants the possession, then in such a case, delay interest will be paid by the promoter on demand to the allotee within 45 days of its due. What are the reasons when an allotee can be shall become defaulter, and what will be its consequences? Number one, if the allotee does not pay two consecutive demands as per payment plan, two landmark amount is due. In such a case, the allotee became a defaulter and he has to pay interest in the prescribed rate. What is the prescribed rate in UP? MCLR plus 1%. Both promoter and allotee has to pay same rate of interest to each other. Promoter should not be himself in demand, but here one is the strict condition that promoter shall not be in default for the same to take this benefit. Promoter, if the promoter is on default may be any of the provision of RERA Act. So if promoter is on default, then the benefit of this section and this provision cannot be taken by the promoter. Further, if the allotee does not pay two consecutive demands beyond the period of 3 months and default continue for it more than 3 months after the notice of 30 days, the promoter has the right to cancel the unit, and after deducting interest and booking amount, he will refund the amount. And but again, he should not be a defaulter himself. For taking benefit of this provision, he should not be a defaulter of any provision of the RERA Act. Conveyance of the apartment means registry of the apartment should be done within 3 months of occupancy certificate or completion certificate. But if the allotee does not deposit stamp duty or registration charges with the promoter, then promoter can withhold the conveyance deed. This is the right of the promoter. Maintenance. The promoter shall maintain the project till the project be handed over to the association of allotee. A very interesting provisions has been given in different states agreement. One is in UP. It says that 1 year maintenance charges is included in the cost of the unit at the time of agreement. So first year, no maintenance charges can be collected from the allottees by the promoter from the date of completion certificate or occupancy certificate. Further, very interesting provision is there in Delhi Agreement to Sale rules and Haryana Agreement to Sale rules. It says that the cost of the unit include maintenance charges up to the date of the project is being handed over to the AOA. Till the project is not handed over to AOA, the allottees need not to pay any maintenance charges to the promoter. So this will create a pressure on the promoter to transfer the project as early as possible to AOA. If AOA is not formed within 1 year from the date of completion certificate, then promoter can increase maintenance charges by 10%. However, the local law means apartment laws, it says that within 1 year, AOA should be formed. It says Apartment Owners Association. Here in the RERA Act, we says Association of Allottees, but in the Apartment Act, it says Apartment Owner Association. If within 6 months where 60% or more possession has been given, or within 1 year of completion certificate. Association of allotee is to be formed. Further, when the project is being transferred to association of allotee, so advanced maintenance charges received from the allottees should be transferred to association of allottees by the promoter. Defect liability, as all knows, there will be a 5-year defect liability on the promoter. It means any structural defect in workmanship, quality, or provision of services as per agreement. The promoter is responsible to correct these liability, these uh, items within 5 years of date of possession, and promoter has to rectify the defect after receipt of within 30 days after receipt of notice or information. And aggravate LOT can go to RERA and claim compensation from the promoter. Basement, uses of basement and service area and other compliances. Basement, LOT cannot use basement and service area and can only the area allotted to him for parking. He cannot use other areas because all these areas are common areas and to be used by each and every allotee and cannot restrict the right of other allottees. Allotee shall maintain his unit at his own cost. Means the whatever the unit is given, the maintenance of his unit inside the maintenance of inside area is to be given is to be done by the allotee from its own pocket on cost. Further, allotee shall not do anything which is a violation of any act relating to the project. Will keep the structure of the project is in the safe conditions. This is very important because the if the structure got weak, then whole the building can collapse. We hear one case of such type of building where the maintenance work was going on in a flat and whole of the building was collapsed due to such a maintenance done by the allotee. Allotee cannot put signboard, nameplate, neon signboard, publicity material, attachment material on the face or common area of the building. Color scheme of the exterior building shall not be changed by the allotee. And you can done only the interior. You can change your color of your internal units. Allotee shall not store hazardous or combustible goods in the apartment. Allotee shall not encroach the common areas. Allotee shall plan and distribute its electrical load in conformity with the electrical system installed in the project. Means when you have booked the unit, you say, I need only 3 kilowatt of electrical supply in my flat. Later on, you say, I need 15 kilowatt because all the systems or all the provisions of electricity will be done by the promoter, only only making estimate of the future use of the uh, electricity consumption. But now he cannot increase the electric load as per your wishes. You have to arrange yourself for that. Further, allotee shall be responsible for loss or damages arising out of any breach of any condition of any of the conditions. Next is binding effect, very important. What is binding effect? Promoter promoter send a copy of agreement to the allotee to sign this and send back. But the allotee refused to sign the agreement or send back after signing. In such a case, there will be a no binding effect between both the parties, and they are not bound with the agreement. Firstly, the allotee has to sign and deliver the agreement along with due payment as per the payment plan given in the agreement, and then within 30 days, he has to return the signed copy of the agreement within 30 days of receipt of the agreement, and then he has to appear before the sub registrar to uh, to execute that agreement, to register that agreement before the sub registrar. If both the things are not been done, then in such a case, the promoter will issue a 30 days notice. And if again the allotee does not come for execution of agreement, there will be a no binding effect. In such a case, all the amount received by the promoter from the allotee shall be refunded to the allotee. This is the provision available applicable in UP only. In other states, I have gone through the provisions of agreement to sale of Haryana. They have mentioned that 10% of the cost of the flat will be deducted in such a condition. So very carefully before booking any flat unit, you have to go through the agreement to sale rules of that state. Then only you have to take a decision about booking of the unit. Amendment in agreement. Amendment in agreement can only be done through a written consent of the both the parties. Number two, when the agreement is registered, then one amendment deed or rectification deed has to be executed before sub registrar also. Otherwise, the amendment will not take effect. Next is provision of the agreement will also be applicable on subsequent allottees. Also, in same way, in case of transfer endorsement of the unit, if you transfer your unit under construction unit to any other allottee or endorsement of unit by done by you, then in such a case, the next allottee will also be bind with the provisions of agreement to sale as earlier done by the promoter with allottee. Waiver not a limitation to enforce. Very important. If a promoter waive off defaults of the allottee, but a promoter has the right to waive off the defaults of the allottee. Means, suppose if a allotee makes payment late, it is the right of the promoter to take interest from him, but he waive off the interest. In such a case, this cannot be used as a precedent in any other matters and not binding on the promoter. So promoter can waive off the default of the allotee, but it is not binding on in other cases also. Further, if a default is raised, if a default is done by any of the persons, it is not a matter that you cannot raise that default after or on finalization of the possession or later on the on the future date. Like if the allotee has done default in payment of installment, it is not necessary to mention that you have done such and such default immediately. At the time of finalization of accounts, at the time of possession, such amount can be collected by the promoter from allotee. And such action cannot be made illegal if such action is taken later on by the promoter. Severability. If any provision of the any para of the agreement became illegal due to change in law, in such a case, the remaining agreement will remain effective and valid and enforceable. You cannot not say that such and such para has been became illegal. So now this agreement became null and void. Place of execution of agreement. Place of execution of agreement. You may write that such and such place is the place of agreement, execution of agreement. So promoter's office, normally promoter's office is the place of execution of agreement. But very important thing is, because this agreement is to be registered before the sub registrar, so the address of the sub registrar will be the place of execution of the agreement. Notices. Both the parties has to mention their address, on which address they can send their notices. Means if an allotee wants to send a notice to the promoter's address will be mentioned in the agreement, and if the promoter wants to send a notice to the allotee, then allottee's address has to be mentioned in the agreement. Any change in the address will be intimated to each other. Joint allotee. If more than one allotee are there, In such a case, communication will be done only to the first allotee, and it will be deemed as the information is also being given to the second allotee or third allotee also. Dispute resolution. How can the dispute will be resolved between the allottees and the promoter? Firstly, the dispute will be resolved amicably, mutual discussion, and if it is not possible to resolve the dispute amicably or mutual discussion, then in such a case, these matters will be resolved through RERA authority. Signature on the agreement. Each and every page of the agreement should be signed by the promoter and also the allottees also. And if a stamp is required of both the parties, then seal of the both the parties is required, and seal is to be affixed on each and every page of the agreement. For the photos of the both the parties, if in case of promoter, the authorized person of the promoter and the allottees are individual, then individual or authorized signatory photos should be affixed on the agreement, and agreement must be witnessed by two persons also. This requirement is also there in the Registration Act 1908, because you are going to register this agreement before sub registrar. And what are the schedules to be attached with this agreement? Number one, description of the agreement, apartment, plot or garage, covered parking applicable, along with boundaries in all four directions. When you execute any registry or sale deed, it is compulsory under the Registration Act that boundaries, all the four boundaries of the unit plot is required to be mentioned in the registered agreement. Here also, there is a requirement that all the boundaries, all the four direction boundaries should be mentioned in the agreement. Floor plan of the apartment. What is the map of your unit has to be mentioned. One map is to be attached with the agreement. Payment plan. On which landmark payment has to be made. As per the provisions of the agreement to sale or under the RERA Act, now only construction link plant is allowed. So first, payment has to be made according to the construction link plan. Further, what type of facilities or specification or amenities is to be provided by the promoter in apartment or plot has to be mentioned in the agreement also. And last is specification, amenities, facilities to be provided in project, which has to be which are also be given in the agreement. So this is my presentation. Now all of you can ask the questions.
Okay. Sir, there are questions. Mm, question by Rishi Bansal. Sir, what would be the situation when my builder intimates that bank account is changed?
Bank account is been changed. First of all, the condition is bank account is condition. All the RERA authorities has issued uh, guidelines relating to the bank account, maintenance of separate bank account guidelines. So that bank account should be in compliance with the guidelines. And if the account is changed, then there is no problem to make payment in the bank account. One more condition are there, that bank account must be mentioned on the RERA authority website, and each and every document issued by the promoter, even the in UP, even every advertisement should mention the bank account of the promoter, where the collection amount can be collected from the allottees.
Okay. So next question is how to know that signing person on the day of registration is the real authority of the promoter?
Very important question, a very good question. That signing person. Now, RERA authorities in UP, they are given on the website that these are the authorized person. They are taking declaration from the authorized person, who are the authorized person of the company, and all the documents. to be issued by him on all the documents which are required to be issued to the allotee shall be issued through his signature only.
Okay.
So
So
you
third,
can verify from the RERA authority website that the person is authorized or not.
okay, so third question is by the Yogesh Chopra. It's a big question. I'm unable to understand, but in short, I think he's asking for the possessions and for something. His question is, he
Allow
and
him to speak. Allow him to speak. We
okay,
have sufficient time for question answer.
yeah, uh, team, technical team, can you just Yogesh sir, you are there? There was a one question by the Yogesh Chopra. So, sir is asking if we can allow him to speak. Okay,
Okay.
okay,
Please read the question. I will try to understand.
okay. Sir, the question is he entered into an agreement in 2014, June 2014, and the builder allotted him 325 yards villa. The builder was the Supertag. In December 2015, allotment letter has been changed because the completion was not made. When the unit finally was not constructed, he filed the RERA petition. Then the builder was allowed either to refund with the panel interest or allot the alternate unit in the same project. So for the 325 yards villa, he agreed to take the two adjacent 200 yards plot. He paid 97.15 lakh in February 14 and the plot allotted for the value of 1.59 cr on March 22. So how will this affect his original purchase date of November 13 when he paid 25 lakh in advance? Now, if he took the possession in 22 October, builder has gone into NCLT on 12th July, OC not yet issued. How this impact his possession? New February 24 insolvency law has provided that in liquidation, possession take buyer will not impact it.
There are many questions raised by Mr. Yogesh
Yogesh.
ji. I would like to say only one thing. Section 62 of the Indian Contract Act says innovation of agreement because they have accepted the new unit. So all the previous agreement will be terminated. And now their right is protected. In presentation, my phone number was there. Even you can note my phone number 9910021080 and can call me. I will try to give him the best solution.
Okay. Sir, the next question is what will happen when buyer has not got agreement registered with the sub registrar?
Very good question. Agreement registered because the right of the buyer has not been hampered. Because once the even in UP, agreement is not been registered by the promoter, but RERA authority is allowing all the rights which are available in the agreement.
Okay. The next
Because
question by
the liability of because the liability of to register the project to the agreement is on the promoter and not on the allotee.
okay, sir. The next question is any guidelines or provision in the RERA if the promoter is not handing over the project to AOA after completing the project and all formalities have done?
Yeah, there are provisions under section 11 and section 17 uh, that promoter has to transfer the common area to the AOA, and even in the apartment act there are provisions that the unit has to be transferred, common area has to be transferred to AOA. I can tell the sections. One is section 11(4)(e) regarding the formation of society, AOA, and section 17 is transfer of physical possession. Uh, section 17.
Okay. The next question is by Tarun Arora. Uh, Sir, I remember that you had mentioned all the clearance should be clearly stated by the promoter. However, the commencement certificate shall not include the fire clearance and other environmental clearance. It is only with the completion certificate that these clearance are received. In this case, if the promoter delay the project or the completion certificate is not received, what are the remedies?
Completion certificate or commencement certificate?
Completion certificate he has written.
If
If
the
the
completion certificate is not been received, then as per section 18, read with para 9 of the agreement to sale, you can claim delay interest from the promoter.
Okay. The next question is, sir, if there are some issue raised by buyer in the maintenance agreement shared by builder, buyer had written an email asking clarification, but no response has came from promoter. Can I stop remaining payment until I get clarity on maintenance agreement? Though the last day of payment mentioned in schedule is already over. What should buyer do or what remedies are available to buyer? Can promoter charge interest on delay in payment?
Okay, one thing is there that RERA Act is not clear on the maintenance agreement. And it says only that the promoter has to charge reasonable maintenance charges till the project is being handed over to the association of allottees. The maintenance charges matter is a matter between the allottee and the promoter, and it should be heard by the competent authority, the development authority. This comes under the Apartment Act, so you have to go there for your remedy.
Okay. So the next question is, when is the property to be conveyed to the society? Conveyed to the society, any timeline, and if not done in that much time, then what were the options for the member? Society.
So society, the property is to be transferred to society, and under the provisions of RERA Act, Section 11(4)(e), it requires that AO is to be formed by the promoter, and after the completion of the project, the project is to be handed over to the Association of Allottees. But when we talks about the Apartment Act, UP Apartment Act, and other apartment acts are more or less similar. They says that when the association of apartment owners association is formed, on the same day, it assumed or it deemed that project is being handed over to the association of allottees. So if the project is complete, you can even go to RERA, because the section 17 says that project has to be handed over to the association of allottee, and even you can go to uh, competent authority or development authority for handing over the project to the association of allottees, association of apartment owners association.
Okay. So the next question is, can booking be accepted by builder from real estate agent if the broker agent is not registered or RERA is expired?
I think this question is from a UP person. I,
Hemant
and
Yadav.
ask him whether he is belong to UP.
Hemant sir, do you belong? Is not able. I think he's not here.
Okay, I will tell the answer. If the registration of the agent is expired, it means there is no registration. And as per section 9 or 10, an agent cannot sell any unregistered project, and a unregistered agent cannot sell a registered project. So in such a case, booking cannot be done by the agent.
Okay. Again, he is asking the same question. I hope you get the answer, sir. Yogesh, sir, you can write an email to sir if any doubt is there. And so the next question is there any regulation mentioned in RERA regarding pricing? That means ensuring the pricing matches the fair value of mark property.
There is no such provision in the RERA because the price of the property decides on the basis of market value. RERA does not interfere in the price of the unit. It is your decision, but at what price you are going to purchase the unit.
Okay. So the again the question is, in agreement to sale, only purchaser has a right to cancel the booking. Now builder is saying that he will cancel the booking on his own as assessee failed to pay the amount as mentioned in the agreement to sale. Assessee ready to pay the amount with the interest. Can we challenge as in ATS only right to cancel
Please,
the
please,
booking
please,
is?
please write. Please read again this question.
Okay, there was an agreement to sell. Only purchaser has a right to cancel the booking. Now builder is saying that he will cancel the booking on his own as assessee failed to pay the amount as mentioned in the agreement. Assessee is now ready to pay the same amount with the interest. Can we challenge as in ATS only right to cancel the booking is with the buyer and not with the builder?
First of all, both the person, allottees and promoter, have the right to cancel the unit. Number two, I have already told the para number 9.1, 9.3 that the 9.3 that promoter should not be on default. If he is on the default, he cannot cancel. If he is canceling, then go to the RERA authority, file a complaint. You can get relief from there.
Okay. Um, Sir, if the case is settled under the conciliation with a RERA and builder agree to give car parking, but now builder is denying to give car parking, what to do?
File a case before RERA authority
Okay,
because the conciliation is nothing but mutual settlement. You can enforce this settlement through RERA authority.
okay. Can separate car parking charges to be charged under RERA and the same mentioned in the agreement?
Yes, but car parking should be either a garage or covered parking. Open parking cannot be charged.
Okay. Sir, earlier that question asked ki booking by builder from real estate or RERA is expired. It was from Haryana, and he is asking ki what are the circumstances of violation, if any.
Circumstances of violation means what means?
Like if the booking is accepted by, can booking be accepted by builder from real estate agent if the broker or agent is not registered or RERA is expired, and what are the circumstances of violation, if any?
Yeah, yeah. Section first of all, if the agent is not registered, then there is a penalty of rupees 10,000 per day under section 62 of the RERA Act on the agent for non-registering of the non-registration. And second, as per section says around 65, 1 minute. And if once is the penalty of section 62, 10,000 per day. And if the RERA authority pass any order on the agent, then it may be up to 5% of the cost uh, of the unit he has booked.
Okay. So does RERA deal only with the buying property or even renting out property?
RERA does not deal renting out properties.
Okay. I think so many of them asking your mobile number and email ID to write all the doubts and things. And can you share the PPT also?
I have already shared PPT in the group, and my phone number is also there in the PPT. And my phone number is 99 100 210 80. and other number is 86300 26152.
Sir, can you write it down and show it in a slide for few seconds so the
I am sharing my slide again, and all can note. Uh,
all the member are requested to just write it down or take a screenshot if you need, because so many of are asking the same.
any other question?
No, sir, all the questions are answered.
This is a very important topic of agreement to sell, and I think who are practicing in RERA or intended to purchase any property should go through the provisions of agreement to sale before signing any agreement. And my presentation is completed. Thank you very much for giving me a patience hearing. Thank you.
Okay. Thank you so much, sir, for giving us so valuable insight and your time. Thank you all the participants for keep joining. So the questions are there. It's like,
If any question is there, we have a time of 7, so we can take questions.
yeah, the Hemant is asking what are the GST rate of BUC?
Means
BUC means Hemant. Can you write over there? The next question is, until he is writing, what are the provision applicable when the project is done under cluster development? Also, what provisions are to be followed when the project is transferred to another promoter?
other promoter.
Yeah.
Uh, I do not know much about the cluster development, so I can skip this question. And the next question is about the change in promoter. The right of the allotee will remain same as per section 15. This is the same liabilities what the previous promoter has will be transferred to the new promoter.
Okay. Yes, team will share you the PPT. So many are asking for the PPT. Any other question member can put over there?
Even if anyone message me, I will share my PPT. Please send me message on my WhatsApp. Both my numbers are on WhatsApp. I can share my PPT on the phone also, on the WhatsApp also.
Okay, sir. Sir, at what stage of project promoter can demand GST?
At what stage of project promoter can demand GST? I am not a GST expert. I am not much dealing in GST, but I can say the GST is applicable on receipt basis, whichever is receipt or due, whichever is earlier. So even the first demand, GST can be collected.
Okay, sir, it was what are the GST rate of basic unit cost? It's BUC.
Basic unit cost. Basic unit cost. It depends. In 2019, there was a lengthy circular issued by GST department. It has given three rates of GST without ITC. On affordable housing, rate of GST was 1%. On normal residential construction, 5%. And on commercial, it was 12% without ITC. Sorry, commercial 12% with ITC. 1% and 5% was without ITC. And in case the ongoing projects means old project which was started before the uh, 1 for 2019, there was an option. They have to file one declaration that they want to continue with old scheme, then in such a case, old scheme of 12% was applicable. But if no declaration is filed by them with GST department, then they will be come compulsory under the without ITC regime, 1% or 5%.
Okay. Sir, in case of change in FAR, how should the builder proceed with RERA?
Change in FAR, first of all, if FAR is changed, it may be two reasons. First of all, the builder has changed the map, or there may be some problems in the construction which force the promoter to change the FAR in a smaller way. In a second way, second matter, no need to take any permission from the RERA authority, but he has to take permission from the development authority in both the cases. But in the first case, permission from the allottees are also be required to taken before changing in the map or FAR, and also from the RERA authority,
Okay.
as per section 14 of the RERA Act.
Okay. Sir, if there are different component of cost like unit cost, parking charges, then the GST would be applicable at which rate? Like unit cost is 5% if residential or parking charges means 18%.
I think this question will be taken by any GST expert. It will be better. I think yeah, 2 days back, the GST Council has clarified that PLC will be a composite supply. So I think the same rate will be applicable, 5% on all the all these on these amounts.
Okay. Whether before RERA certificate GST can be demanded?
Whether the before RERA certificate, even no amount can be demanded.
Okay. Please inform. Sir, can you share once more your mobile number and a mail ID if you member missed it? PPT can be shared on email, Gandeep sir. Any other question member can ask? Sir, what is the status of possession given by builder before OC is with promoter?
Before OC is given by promoter.
Yes.
Okay. Uh, when we talks about the possession before OC, there is a provision of deemed OC under the Apartment Act and also in the Urban Planning and Development Act. As per RERA Act says that possession should be given on OC or CC as per the local laws. So we have to go to the local laws, what they are saying about OC and CC. There is deeming provision under the Urban Planning and Development Act and also under the Apartment Act. There says that once application for OC or CC is being applied, I am talking about the UP only. And if there is no objection is raised by the competent authority or development authority about the application, then in such a case, and no OC or CC is being issued by the competent authority or development authority, in such a case, after the lapse of 3 months, it will be deemed and that OC or CC has been issued to the promoter.
Okay.
So you have to go through from your state laws, local laws, to check whether what is the time period given in the uh, local laws about the OC or CC.
Okay. Sir, again, I think Hemant Yadav is concerned about the GST. He's again asking that on the OC received projects, can GST be charged on parking components?
In case of OC is received, and if the booking is taken prior to the OC, then in such a case, the GST can be charged. But If you have booked the unit after the OC, then there will be no GST.
Okay. I think all questions are answered, sir.
1 or 2 minutes, take 1 or 2 minutes more
Okay. Okay. Member
because
can put their query.
we have 10 minutes left.
Yes, sir. Sir, if RERA of a project expire, then what will be position of buyer?
What will be the position of a buyer?
Yes, sir.
Buyer's position will not be effective about after the lapse of registration, and buyer's right will be there as it is.
Okay. Any other questions?
My suggestion is one suggestion I am giving to all of you who are interested in doing RERA practice. Our CA Institute is carrying on one certification course on real estate laws. Please, all please join that course, and you will get knowledge about all the laws which are applicable on real estate, and it will be more beneficial for all of you in your day-to-day practice. Even the income tax, GST, RERA, Apartment Act, and environmental law, Registration Act, Transfer of Property Act, Indian Contract Act. You will got exposure of all the acts, and it will be very much beneficial. So I request all of you to join that course, and if the institute will give me opportunity, I will be there as a faculty in that course also.
Sir, what is the role of CA in this act? Like only they provide consultancy with respect to this, or
RERA,
somehow? Yes, sir.
as a chartered accountant, you can do everything, whatever an advocate can do. Even you can do more than the advocate, because Section 56 allow you to represent your client before RERA authority and RERA tribunal. I am myself litigating case before RERA authority under RERA, and also uh, certifying the documents. So you can do compliances also, you can do litigation also, and this is a very good field for each and everyone.
Sir, for compliances part, like it is required a chartered accountant to do all the
No,
compliance.
but chartered accountant certificate is required.
Okay.
Quarterly certificate is required for withdrawal of money uh, from chartered accountant, and it is to be done by a practicing chartered accountant other than statutory auditor of the company or the promoter.
Okay. So there are questions.
And also, the statutory auditor of the company has to issue one annual certificate.
Okay. Is it mandatory to physically sign the application form, or can we fill online?
For what?
I think Hemant Yadav, it's incomplete question. Is it mandatory to physically? Don't know. Next question is, can RERA of a project can be in parts? In parts.
Truly speaking, registration of the project cannot be taken in parts, but in practical way, the promoter is taking registration in parts. As per
Okay.
that, in my opinion, there is no provision when a when you approved one project from development authority and take registration, RERA registration in parts from the RERA authority. As per
Okay.
the RERA Act, I think, in my opinion, Section 4 clearly states that you have to take one registration for one, as it is registration, as the competent authority has allow you the sanction plan of the project.
Okay. Sir, what will happen if the builder is not signing BBA?
As per Section 13, it is mandatory for a promoter to take to sign BBA after before taking more than 10% of the cost of the unit. If he is not signing the BBA, this is the responsibility of the promoter and not the allottee. You can go with you can file a complaint before RERA authority, and RERA authority will give you relief and
Okay.
force the builder or promoter to sign the BBA as per the format given in the rules.
Okay. Sir, in how many days I need to register the property after possession is offered by the builder or one full payment is made?
Yes, payment, full payment is not a matter because there are so many matters. Because in Noida, the builder has taken full payment, even got OC or CC, but he has not made full payment to the relating to land to the development authority. In such a case, development authorities are not allowing uh, to register to execute sublease deed. So, and as per law, there is a provision for take possession within 2 months of OC or CC and execute registry within 3 months of OC or CC.
Okay. So there is a question that how much a CA can earn from one builder client.
One builder, it depends upon you.
Okay. Uh, I think every question is asked. When the agreement to sale is executed in Mumbai, it is asked immediately on payment of 10%.
Please read it again.
When the agreement to sale is executed in Mumbai, it is asked immediately on payment of 10%.
It depends upon payment plan opted by you in the agreement.
Okay. Any other
Because you
questions?
have opted the payment plan in the booking form or the agreement to sale. Then if it is due, then the promoter will ask you for payment.
Sir, how much time will it take to take that RERA certificate or RERA?
Sorry.
How much
Please.
time it take to take the RERA certificate or RERA? The project is approved by RERA. We have to obtain that license, na? So how much time it take?
For obtaining RERA registration
Yes, sir.
of the project.
Yes, sir.
As per law, as per Section 5 of the RERA Act, 1 month time has been given. And if if any objection is raised, then the time taken by RERA will be more. Otherwise, if there is no objection to RERA, then the registration will be deemed.
Okay.
And after 1 month, within 7 days, RERA authority has to issue registration certificate of the project.
Okay. Whether promoter can demand money before RERA approval?
No, Section 3 clearly states not to the promoter cannot book marketing sale advertisement before the registration of the project.
Okay. In UP, can builder forfeit booking amount before BBA?
No,
Okay. Any other questions? I think all the question is answered by the sir. Once again, I am sharing you the sir. Sir, can you please share your slide for your email and that? All the member are requested to just take a screenshot or a picture of that. You can ping to sir with respect to your queries or anything. Okay. Thank you so much, sir. Thank you so much for your time, for your presentation, for your expertise, knowledge, and
It's my pleasure to give a to give my views on RERA, and hope the members join this program has got benefit from this program. Thank you very much.
thank you. Thank you so much, sir. All the members are requested. Yes, the you can take the once again. I am sharing the slides. So can you please share your slide with respect to the phone numbers? The same questions are coming over there. Okay. Thank you so much, sir, for your time. Thank you, all the members and participant. Thank you.
Thank
Uh,
you.
okay, shall we wind up, sir?
Yes, yes.
Okay, team, are you there? Wind up, correct? Thank you, sir.